matter of Optis Cellular Technology LLC and others, Apple Retail UK Ltd and others.
Mr. Speaker.
Lords, this is an unusual appeal where very many points arise, and how best to present them all is something I've agonised over a great deal, and it's a particularly tricky task because of the time constraints. For example, going straight into ground one about the overarching errors is something that's going to be quite difficult to do before I take my Lords through the detail of the key sections of the judgment. So what I've concluded the most efficient way to develop the arguments in our skeleton is in fact to spend some time covering the judgment before getting into the specifics of any of the grounds. So what I propose to do, subject to my Lords, is to begin with an overview of the basics of valuation in Fran cases, the methods typically addressed and the premises underlying them. That will lead me naturally on to the topic of what each side's respective cases were before the judge, including specifically the differences but the elements that are in common between the expert's approach, which will lead me naturally to the valuation judgment itself. And as to that, there are two key sections. First, those parts where the judge rejects the parties' expert evidence and the cases that they were advancing, and the second where he sets out and explains his own novel approach. And going through those aspects of the judgment is in fact a very major task, but I think that the time spent here will repay the effort in terms of the manner and efficiency I'll be able to make my submissions on the rest of the case. I actually anticipate being at least well into the afternoon on that. Having reached that point, my Lords, we'll be actually totally immersed in the detail of what the judge did, which is in fact the detail of our complaint as to the errors of his own method. So that's grounds 5 to 10, actually 5 to 9 because Apple have conceded ground 10. And so what I've concluded that it's most efficient to do is to continue on those grounds and how they may be fixed. My Lords, I hope appreciate that my primary case is the judge shouldn't have gone down this path at all, and he should have looked at the comparables as unpacked by the experts, specifically the Google license and the Qualcomm license as the most reliable evidence. And that does remain my primary case. I don't want my Lords to lose sight of that, but it would, I think, be disruptive to the flow of my submissions to go and do that and then come back to the detail of what the judge actually did. So I propose to deal first at that point with grounds 5 to 9, identifying the judge's errors in his own method before coming back to my primary case, which I will come back to next, actually first by dealing with the thorny issue of legitimate or illegitimate holdout, because logically that's actually an antecedent point and in fact is overarching everything, even my complaint as to the judge's own method. And then I'm going to take grounds 2 and 4 together, which are the two sides of the same coin in the error of rejecting a comparable approach and adopting his own method, explaining what the judge should have done and how this court can deal with correcting this by way of its own view. And having done all of that, I'll then be in the best position to come back and deal with the overarching errors that we've identified in ground 1. And I'll be able to address those actually very efficiently given what we will already have seen. By that stage, my Lords, I'll be on the home straight, at least as regards my submissions. There'll be two topics left for me to cover. I should interject, we've told my friends that given the time constraints, we've taken a decision not to press the appeal as regards the ex-Ericsson patents, so that's ground 18. So the first of the remaining topics for me will be the grounds relating to the draft judgment, permission for which we applied for separately and were granted by my Lord Justice Arnold. And finally, I'll address the topic of the US proceedings, which actually span several grounds, and the problem that arises by virtue of there having been long-standing parallel proceedings in Texas that have reached a raised judicata judgment. That in itself is a not insubstantial topic to grapple with. Lords, the aim is for our submissions to finish somewhat before lunch on Thursday, with however much time we leave before lunch being time for our reply at the end of Monday. I personally hope to finish Thursday morning, leaving at least 45 minutes or even an hour for my learning from Mr. Abrahams, who's going to deal with the other aspects of the appeal relating to other licence terms. So that's part 2 of our skeleton. insofar as I've not touched upon those as pertaining to the topics I'm covering. So there's a lot to cover. Before I get cracking, can I mention some housekeeping matters?
Yes.
First, confidentiality.
Yes.
There are two aspects to this. The judge dealt with the issues of commercial confidentiality at hearings subsequent to the judgment, which actually involved a lot of other parties. They have an interest in keeping matters confidential as well. And that decision is also subject to a pending appeal. And so what we've done is mark up the judgment and the appeal skeletons, showing as confidential not only those aspects that the judge held to be so, to be redacted, but also those which are contended to be so on appeal, so as not to prejudice any appeal. What we've not done is remark all the documents which were trial documents in the bundles, so we may open up documents having marking that indicate much more is confidential, for example, the identity of parties. But that's a hangover from what the arguments were at trial. My lords needn't worry about it, but just so that you know that there are more extensive markings on documents that are old, as it were. I believe I can argue the appeal in open court without referring to anything that is or after that appeal might be confidential. It might mean pointing to numbers and the odd passage of text and the like, but that's my hope and belief. Obviously, we're also looking at documents in court that have confidential information in, and we don't want to prejudice that confidentiality appeal. So what we've done is agree, subject to my Lord's an order, which I hope will have made its way up. Is there a problem with it?
No, there is no problem with it. I was going to say that we are content to make an order in the terms of the draft with which we have been
I'm very grateful. It's just a pro tem.
Yes.
It may be revisited after the appeal. Another aspect of confidentiality is something that I've agreed we've agreed with the other side I'm going to raise at the outset, not because either of us wishes to go into private to deal with the issue, but we thought it right to raise it. And it's this. The unusual aspect of this appeal is that some of the grounds we have permission to argue pertain to the draft judgment. And as I've already said, we applied separately for permission, pointing out that we needed permission to rely upon the draft judgment, which we obtained. The point that's been raised by Apple is for me to make sure that my lords don't wish to go into private when I refer to the draft judgment. I assume the rationale underlying the suggestion is that you might want to give judgment on it in private because draft judgments usually are confidential forever. I have to say it never occurred to me until they raised it, but we didn't want to do anything to prejudice that point.
I don't think it has occurred to us either.
Right.
Are you going to be getting onto the draft judgment this morning?
Possibly towards the end of the morning when I look at what is in the judgment, because there are parts of it where I do have to show my lords how we got where we are. And I have given some consideration to whether or not I can just do all of that in one chunk, and it's not particularly easy to do that. So if my lords want to hear about the draft judgment, we would have to go in and out of private a bit.
Yes.
I don't think that was done in the cases where
No.
draft judgments were examined by this court before.
No, I agree. It's a point that the other side wanted me to raise, and it hadn't occurred to me that that would be necessary. But I thought it right to raise it rather than to prejudice it. And for instance, we haven't let anyone have our skeleton until my lords have said what you want to do. I'm not suggesting you do need to go.
No, Mr. Turner.
My lord, we're not pressing it. It's in the court's hands.
I think we're content to proceed without going into private.
I'm very grateful.
Just one other housekeeping thing before you get going. On Friday, we need to rise at 3 o'clock. Now, subject to anything that you may want to say, any of you, I'd propose to make up 3/4 of an hour on the Friday by sitting at 10 and cutting lunch down to 3/4 of an hour. Now, you will still be half an hour down. If it looks as though we need the extra half an hour, then I'd propose that we sit at 10 on Monday, but we don't perhaps need to make a decision on that now.
I'm very grateful. That sounds very sensible.
Anything you want to say, Mr. Turner?
No.
No. Thank you.
There was one final housekeeping matter, and that's the status of documents in Bundle Supplementary 4. which were previously not agreed to be included in the appeal bundle. I'm happy to report that that's now agreed, subject to my lords, and in fact my friends have identified further documents from the trial they wish to refer to, which are in supplementary 5, which we obviously don't object to either.
Yeah.
Can I start by addressing the two methods of valuation that are usually an issue of cases of this kind and were deployed before the judge in this case? I'm going to start by describing them quite generally. I know two of my lords will know exactly what I'm talking about, and I will take it as quickly as I can. There are two methods that are typically involved. One is called comparables and the other top-down. Very broadly, the comparables approach is an approach that involves looking at previous transactions or agreements, particularly those which might be considered to have similar characteristics. And typically one is looking at licenses relating to the same portfolio or at least a part of it. And one's looking to the circumstances of them to assess how comparable they are to the circumstances one's assuming for the license being settled. And the two previous cases before this one, Unwired Planet and the Interdigital case, the judge in each case adopted that approach and in fact determined that there was in each case a single licence in the evidence which was the best comparable upon which to base the valuation. Before I describe the issues that arise in a comparables case in a bit more detail, I should just identify the other method, and that's referred to as a top-down case. And what one's doing in that kind of case is working out what the overall royalty it is fair and reasonable for an implementer to pay for the technology as a whole, and then working out the share of that particular patent owner that they may be entitled to of that overall royalty. So in broad terms, working out the size of the pie and then work out how big the particular patent owner's slice of that is. And one can see that in that exercise, those two principal parts, assessment of what the overall pie is and what the fraction is, are two separate exercises, and once you've done them, the rest is just a bit of simple arithmetic. I should say that this simple top-down approach can be deployed as a cross-check, which is actually what my Lord Justice Birss did in Unwired Planet. And what you're doing there is using it as a sense check, and it perhaps might be better called a bottom-up approach because you don't actually independently work out what the pie is. You use the number that you've got from your principal method and then test it by working backwards. What you need, whether you're doing it backwards or forwards, is some measure of the share of the stack. And in previous cases, that's tended to focus on seeking to measure truly essential patents and an assumption that every family of truly essential patents is worth the same. In this case, when carrying out his own valuation, the judge preferred to use a method that simply sought to work out proportions of patents declared essential. And so he just used a method which purported to count the number of declarations and leaves out of account an issue often referred to as the over-declaration problem. That's an issue that wouldn't cause a problem if everybody over-declared at the same rate, because all you're working out is a fraction, a share of the pie, but some patent owners are much more liberal with their declarations, others more conservative. So there's a recognised issue in simply using declarations. And typically trying to deal with the over-declaration problem is where reports undertaken by the likes of PA Consulting come into the picture. They're a major technology consulting business, I think based in Cambridge, who review the entire patent landscape and assess the veracity of declarations. But in this case, the judge preferred a method that ignored that dimension. Perhaps another manifestation of this preference was stripping back pretty much all aspects of the analysis to numbers untouched by any kind of expert consideration. Another aspect of that will be apparent, my lords, when we get into the detail, is that he rejected reliance on any kind of measure of projected sales or revenues. that both experts were agreed would be part of the valuation exercise. And what I mean by that is one of the aspects that was common between the parties was reliance upon an assessment of what negotiators would likely have in mind as to projected sales, but he rejected that too. Now, before I address comparables in a bit more detail, can I just draw attention to a point that actually applies across both methodologies, and that's the difference in talking between of a royalty or a price per device in ad valorem terms or absolute pounds, shillings and pence, more usually referred to as dollar per unit. We'll see in this case that the judge actually rather lost sight of the latter, the dollar per unit, and got in a muddle thinking that the two alternatives being advanced were ad valorem or lump sum as alternative methods of valuation. So he hardly ever refers to the dollar per unit. When he does so, he typically calls it a per unit rate. Of course, strictly ad valorem is that too, but in context it's obvious he's meaning DPU. And I'm going to use DPU as the term to be clear. And just to explain very briefly, the point as to the difference between working in ad valorem and DPU can be of some significance because it matters at the point you decide to take the price worked out in the context of one implementer and use it in the context for a different implementer. And I can illustrate it very easily. If I've got two implementers, one with an average selling price of $400, one with $200, and the first is paying a royalty of 1%, so that's $4. If I want to offer the other implementer the same price, what do I offer them? 1%, $4 for one, is 2% for the other. So it really matters which dimension you think is the correct one at that point in time when you move from one implementer to the other, but not so much at earlier stages. And there's a further sophistication that one often sees referred to, and that's caps and floors, which interacts with this issue as to particularly the ad valorem and the DPU. So instead of just saying I'm not going to have the variation in price varying with the value of the phone at all, you can have a kind of hybrid where you have a cap or a floor, and a cap is applied in the context of ad valorem schemes where the implementer pays a percentage to reflect varying degrees of value of the technology with increasing device specification, but only so far. So you might have a cap of say $400 or $250. So more expensive handsets don't pay more, they pay whatever it would be as if they were $250 or whatever your cap.
You enlighten me on this. You just referred to as caps and floors as if typically they apply to the sales price. I mean, is that right, or is it more usual for caps and floors to apply to the royalty? Or is it both?
It's both, I think, my lord, in the sense that if you actually negotiate it as part of the negotiation, you apply it when you're packing up how much is paid. But then when you're unpacking, you might, and we'll see that Mr. Bazant did unpack the Apple licenses, applying a cap of $250. So when he was going to an ad valorem rate, he was using that as a cap, assuming that they didn't pay ad valorem right up to whatever the price may be, which obviously for Apple phones is a lot higher. So it comes in both circumstances. In a real life negotiation, it may be something that it's the way you negotiate, but also when you're unpacking, it's part of what you have in the on the picture that you're using to try to work out what it might equate to as an ad valorem rate.
Okay.
And as I think I was just saying, that schemes like that seek to balance the two sides of the argument as to whether or not price ought to vary, royalty paid ought to vary with price. And they allow it to do so in the middle ground, but then only so far. In terms of whether you pick DPU or ad valorem, my lords, Lord Justice Arnold and Lord Justice Birss will perhaps recall that in the previous two cases, there was one of each. My Lord Justice Birss worked in ad valorem in Unwired Planet, and Mr. Justice Mellor worked in DPU in Interdigital. And there was a dispute between the parties in this case as to which was the most appropriate to price the royalty in. But the judge did something completely different, working in lump sums as a valuation method, not simply as a payment structure. Despite the fact that no party did that, and even after we jointly tried to point out his error, saying lump sum was not a valuation approach but merely a payment structure, he doubled down and rejected that, wrongly stating lump sum was a valuation method used by Apple in this case. And we see that in the judgment, for example, in his footnote 59 on page 260 of Core 1. Got a big footnote at the bottom of 260.
In the version I'm looking at, it hasn't. That's probably.
It's in Core 1, page 260. It should have footnote 59 at the bottom.
Yes, I hadn't realised this version of the judgment I pulled out here has slightly different page numbering.
Oh.
Yep.
And this is one of several places in the judgment which actually make for very uncomfortable reading for those who were at trial, because it really does reveal how little the judge actually grasped as to what was being debated in the evidence and submissions before him. I'll show you later, but we both agreed that that wasn't Apple's case, and that the lump sum was a payment structure, not a method of valuation, but he rejected what was agreed between us when we tried to correct him afterwards. And that's a pretty fundamental error, as I will explain. Now, for this appeal, as to the distinction between ad valorem and DPU, for simplicity we'll be sticking with DPU. The numbers that I'm going to show you are going to be DPUs. It's Apple's preferred method, which enables us to use Miss Guttridge's numbers and indeed Mr. Bazant's DPU version of his equivalent unpacking. And in fact, it makes no real difference for our purposes, particularly when the licenses have been unpacked using a cap rather than based on all the revenue. I said a while ago that I was going to explain a little bit more about what the exercise is when you're using comparables, and can I do that now? I've already foreshadowed typically what one's seeking to do is to look to previous transactions and the information that you can get as to the price from them, which then can be used to give a guide for the price and perhaps other terms in the putative transaction that you're considering. So there are two main parts of the exercise that I want my lords to grasp. First, you look at other transactions to assess how comparable, if at all, the transactions are. In this case, that means looking at the circumstances of those other deals, including how the implementers were placed in the market and other circumstances that may be considered to have an effect on the deal, whether it would have been negotiated on both sides forcefully, but, and this is crucial, without improper hold-up or hold-out. And of course, what we mean by comparability here is how comparable the license you are looking at is to the putative agreement, i.e. the thing you're valuing. You're not, in this consideration, worried about how comparable a given existing license is to another given existing license. It's how comparable it is to the transaction I'm valuing. And the second main aspect of this exercise is what information can you get from the agreements as to the royalty that is agreed, because many have a degree of complexity such that the unit price can't simply be read off the paper. and specifically many with the bigger influences not expressed like that in terms of payments for each unit sold, but some form of lump sum or perhaps series of instalments which can be equated to a lump sum on day one. Now the first broad issue I identified, how comparable is the transaction, applies to all agreements, even those of the simplest type. Say a licence entered into prospectively with no past sales, expressed as a royalty per unit, say 1% of average selling price or $1 per unit, whatever it is. Those agreements need to be assessed for comparability just like any other, but they may have no or very few issues in the second broad category because you can just read the price off of it. Of course, my lords, the overall utility of any agreement will involve an assessment of both of these. But they are separate issues. And the second issue, what kind of information can you extract from the agreement, is something that I want to focus on now, if I may, for a short while. And I want to explain the nature of the exercise. And what I'm going to do is do it with a particular focus on agreements where the payment structure is a lump sum. So let's think about a deal covering a particular period of time where the amount to be paid is not expressed as a sum of money per unit sold. The simplest would be a lump sum for a given amount to be paid on the day the agreement was signed for a licence extended, say, 5 years into the future. And perhaps the first thing to note is what you're doing, certainly both experts were working on the premise, is assuming that whilst negotiating parties have a preference for lump sum payment structures, you don't have to have royalty statements and it's done and dusted, they're actually working to a deal with a number of units to be covered in mind and negotiating an overall consideration to reflect those projected sales. So at the most simple level, one is assuming that the parties have in mind a level of projected sales. Of course, they might not precisely agree that separately, but they have it in mind and they negotiate an overall price that reflects a royalty per unit packed up into a lump sum payment structure. And that, I might add, is why it's always common ground in these cases that one doesn't look to see what sales were in due course actually made. Company may have fared better or worse than would have been projected. One always looks in some way or another for what one thinks the best measure for what the parties had in mind as to the likely sales at the time they were negotiating the deal. And both experts did this. There were differences in the detail they used to do it, but both used projected sales units in their valuation method. And they were valuing in terms of a price for each unit projected to be sold. Of course, it's only in very rare cases that the parties actually separately agree the projected units with any accuracy. But one is ultimately concerned with seeking to use the best information one can to extract the royalty per unit from the details of the lump sum. And that's so, my lords, whether you're of the view that DPU or ad valorem is the more appropriate rate to look at. You're doing the same thing. Another one of the things that one assumes the negotiators take account of is the accelerated receipt with a lump sum arrangement. So if one considers the agreement would have been perceived as covering 100 million units, say at $1 a unit, at a simple level that's $100 million, but you wouldn't expect negotiators who are thinking in terms of 100 million units at $1 to then translate that to a lump sum of $100 million. Because the money's being paid up front and indeed the sales haven't actually been made, so there's uncertainty there. And there's a technique we refer to as present valuing or net present valuing. The fine detail will depend upon how those units would have been projected to have been made. And the reality is one might typically discount not just the money for accelerated receipt, but also projected units. And the two discounts are often at different rates. Don't worry about the detail. My point is one expects the lump sum to have been discounted, let's say to $90 million. And one of the things that one has to do is to unpack that when you're unpacking an agreement to get back to a unit value. So you do the opposite of what one assumes the negotiators were thinking of. But that's all conventional. Another complication that may arise is a cross-license. What if the license agreement provides for a payment of a lump sum by one to the other, but the license actually, it goes both ways under each party's standard essential patent portfolios? Well, it's actually not that difficult an issue. Conceptually, it's very simple. In the case of a license with no cross-license, what you're basically doing when working out a unit price is using a very simple equation. Consideration paid is the lump, i.e. the lump sum is equal to the price times the number of units, that's if you're in DPU. If in ad valorem, consideration equals revenue times the ad valorem price. And you can work out the unit price if you know the projected units or the projected revenue respectively. Of course, the net present valuing is overlaid on top, but at its heart, it's simply as I described. Now, if one has a cross-license, the equation is much the same. It's just the consideration is equal to the unit price for portfolio A times the units to be sold under that, minus the unit price for portfolio B times the units to be sold under that. But my lords will have spotted there are now two unknowns, the two unit prices. But if you have a measure of the relative strength of the portfolios, you have another equation. Unit price A divided by unit price B equals that relative measure. And it's a very simple exercise, simultaneous equations that we all did at school. You substitute one in for the other, and you can find the unit price you're looking for. So conceptually, cross-licensing is an additional complication, but not much of one, my lords. Not much of one. And just to be clear, unpacking, whether you're doing it in DPU or ad valorem, requires this extra piece of information where there's a cross-license, the measure of the relative size of the two portfolios. The additional thing you need when you're unpacking where there's a cross-license is that. You don't need the absolute sizes of each, just the ratio. In this case, in fact, in all cases except one, I think, which is the Huawei agreement, it doesn't really matter if you use PA to get that ratio, as Mr. Bazant primarily did, or inography, as Miss Guttridge did. But in any event, it's simple arithmetic to substitute one into the exercise for the other. And in fact, Mr. Bazant included in his underlying spreadsheets the ability to switch between PA and inography for this. And we'll come back to this because it's a point Apple raised as to the detail of possible corrections to the judgment to account for the judge's own method. But I just want my lords at this stage to understand that you need that extra piece of information, just the ratio where you've got a cross-license. Can I pause at this point and draw attention to another point that I've already foreshadowed, which is the effect of a cap. And if you're in a world where you considered the ad valorem price would be subjected to a cap, you're considering a licensee where the cap would have been hit, as we are for all Apple licenses. You're in a world where the conceptual difference between AV and DPU becomes vanishingly small, as I foreshadowed in my answer to my Lord Justice Arnold a while ago. In fact, you're really dancing on the head of a pin. And that's because when calculating the AV rate, instead of looking to work out what the license consideration is divided by the whole of the revenue, one uses as the revenue the cap multiplied by the units. And so one can convert the AV rate obtained back to the DPU simply by multiplying by the cap that you've just used. And I believe that was common ground before the judge. Can I show you that? To do that, I have to go to Supplementary 4, tab 3. This is a page from Apple's opening. And you see Apple explains in the second half of para 172 that you can convert AV to DPU or DPU to AV by multiplying by the ASP or dividing by it, or in the case of Apple, the 250 cap, which is what Mr. Bazant used. And the topic is addressed in a little more detail in Apple's closing, which is at tab 5, foot of page 69 of the bundle over to page 70, where they explain he unpacked to arrive at an AV rate subject to a selling price cap of 250. They go on and say there's no principled or evidential basis for the cap, but then they go on and say as it's below the selling price, it has the effect of operating similarly to a DPU. And they give a reference to Mr. Bazant's cross-examination. So they conclude it makes little practical difference whether Miss Guttridge's DPU rates or Mr. Bazant's capped AV rates are used to consider the Apple comparables with each other. I'll see the with each other underlined. It's making the point I referred to earlier. It's in fact only when you start to price or take a price expressed one way or another and seek to apply it to another implementer where it starts to matter. And both sides fully appreciated this, but I have to say I don't think the judge did. As I've said, he didn't even understand that Apple's preference for valuation was DPU as against Optis's preference for AV. Whilst on this issue, my lords, it's worth pointing out that, in fact, Mr. Bazant did do the exercise of converting his free release AVs into DPUs so that they could be directly compared to Miss Guttridge's free release DPUs. I think that was his 5th report where he simply multiplied the AV rate by the $250 cap. And in fact, we provided the judge a table attached to our closing where the DPU equivalents to all 3 of Mr. Bazant's AV unpackings were included. And I'll show you that. It's a supplementary bundle 1, tab 5. This is an annex to our closing. It's page 117 of the bundle. And what I'm drawing attention to is the penultimate column. So this is the Optis unpacking. And every one of them is given both DPU and AV equivalents. So all 3 simple, in fact simple 50% discount and adjusted are his 2 ways of doing adjusted. I'll come on and explain that. And free release, they're all given because it's a very simple point of arithmetic to do precisely what Mr. Bazant did for his free release, and we did it in closing, so the judge had them all. And in fact, that document is the basis for the spreadsheet that we provided Apple with our skeleton, which I'll come on to. My lords, that brings me to a further feature that may complicate the picture with an agreement where there's a lump sum payment. And that's this point, that the royalty calculation may have attributed no payment for sales in the past, or perhaps there was some value attributed, but the price was substantially discounted for those. Therefore, the overall consideration will be affected by the degree to which a particular implementer has made unlicensed past sales that are released. And this is a well-recognised fact that is regularly a feature of real-life licences, even though it's not in fact FRAND. And my Lords, Lord Justice Arnold and Lord Justice Birss will recall it was the heart of the interdigital appeal. And this is where the different bases of unpacking come in. So just to explain, a free release basis assumes that none of the consideration is attributable to the past, even though the licence may typically have words that dispose of any potential claim for those past acts. So it allocates all the consideration to the future, and in fact it is the only thing that Apple's expert, Miss Guttridge, did, no doubt recognising the common practice. We were somewhat surprised that Apple seemed to be arguing that this is not in fact common ground. And let me show you Apple's reply closing that referred to both Apple's written evidence and ours, that of Mr. Stasic. And for that you need to be back in supplemental 4, tab 6. please go to page 75. So this is Apple's own document, and you can see that we're on the issue of ignoring the common practice of discounts for the past at para 198. And at para 199 at the foot of the page, they point to evidence of what is happening in the industry generally, and they refer to two things. First, Apple's own written evidence about its licensing experience, and that's Mr. Ankenbrandt, which on this aspect they point out I did not cross-examine. I would add because it's entirely in accordance with our case. And the quoted evidence makes 2 points, one to do with discounted price on past sales and the other is payment of interest. Both are in fact non-FRAND features of real-life licenses, and Mr. Ankenbrandt is absolutely clear about what Apple's experiences are. Licensors generally accept a substantial discount on those sales, and that is consistent with the static evidence they quote in subpara B. And just so that you, my lords, understand, Apple was at the time seeking to have the benefit of these real-life practices in its license. But today, we know that they're not FRAND, and they can't have it, so there's been a change of tack. They now seek to argue that although this is generally true in the industry, it's not true for the Apple licenses. I think they want my lords to think they've been paying full whack out of the goodness of their hearts, even though everyone else was getting the substantial discounts. And I'll hear what they say about explaining away the fact that Mr. Ankenbrandt, their fact witness, was expressly giving evidence of Apple's experience. My lords, just on this, I also draw attention to the fact that it is inexplicable that their entire case would advance on free release unpackings of their own licenses too, if in fact they were paying as much for past sales as the future. So free release is the most straightforward approach. One doesn't have to worry at all about how many sales in the past might actually, as a practical matter, be covered by the release. And by that, what I'm referring to here is a point that did arise when Miss Guttridge answered the judge's questions, which we'll come to. Because if you have wording that just simply releases sales for the past, you have to work out or have some idea as to what, as a practical matter, might have been covered. And let me just point out why that might matter. For example, if it's a renewal license, you might still have those words, but practically nothing in the past was not already licensed. Or there might be a partial renewal, perhaps earlier standards were previously licensed but not the most recent. Whatever it may be, the implementer may be a relatively new entrant. Those are factual issues that you need to address if you're starting to take account of past sales, but you don't need to for free release. If you do seek to take account of it, you have to work out how many units they are, but then you can do something that Mr. Bazant called simple unpacking, and that, just for my lord's note, I think you've probably grasped it, that's where all units are assumed to attract the same value in the negotiation, whether they're past or future. So Mr. Bazant did simple and he did free release, and I'm sure you'll have appreciated that those two are kind of either end of the spectrum. Free release attributes no value to past sales, and simple attributes full value. So Mr. Bazant also carried out what we've called adjusted to, and that was his best attempt to reflect a real-life allocation of the reduced value, but not zero value for past sales. So it's a middle ground. And this adjusted unpacking was sometimes carried out by looking at details specific to the license, but in some cases he applied a simplifying assumption to past sales that they were valued at 50% of full value. And that's why you saw it put two ways in the Annex 5 that I just showed you. There are two ways in which he did adjusted, depending on the circumstances of the license. But the upshot is Mr. Bazant provided these three different bases for unpacking, whereas Miss Guttridge only the free release. She was content to treat all the consideration as being paid for future sales. Now, my lords, I've now got to the stage where I think I can outline the parties' cases that were actually advanced at trial. And I do this so that my lords can understand the detail of the judgment that we look at and the details of the arguments we're going to be engaging in, but also to deal with my friend's attempt to suggest that my clients were to blame for some or all of the procedural issues in the case. They suggest due to changing its case and an allegation of being deliberately unhelpful, in particular dealing with questions from the judge. Before I get on to that detail, can I start by outlining at a high level what each party was advancing? Both parties had what one might consider a conventional comparables case. That is, unpacking previously entered licenses to a price per device, which can then be taken as indicative of a price for Apple to pay for each unit. And I'll expand upon what that was shortly. Both parties also had top-down cases. They had different ways to assess the top, i.e. the overall size of the pie, and different ways to measure the size of the portfolios, which I'll elaborate shortly. My client also had a case that one could look to the decision in Unwired Planet. The portfolio in that case now forms part of the Optis portfolio. Optis's portfolio is substantially larger, but we had a case that the data that one got from the Unwired Planet decision, you could scale from that. And indeed, we argued that people in real life in fact did do that in negotiations. They did precisely that. That case was not dropped and formed part of our position statement that we served with our evidence in chief to support our positive case. And perhaps I can quickly show you that position statement. It's at Core 3, Tab 2.
Will we be needing supplemental 4 in the near future? So
I don't think so.
I'll risk putting it away.
Yes.
So it was Core
3, Tab 2. And one can see on page 23 the index in this document. And just to put my lords, to orient my lords, you may have grasped that what the judge did in this case was he made quite an unusual case management decision that in effect we were going to have fresh pleadings served with the evidence. And so each side served their evidence with position statements for their positive case at the same time. And this is what I'm showing you here. And you see in the index, section B3, the three methodologies I've just outlined my client adopting. Scaling from Unwired Planet, comparables analysis, and top-down cross-check. Now my lords know my clients preferred Optis comparables and preferred to express the price per unit in ad valorem terms. In fact, the Optis licenses were generally ones where the price could be read from the face of the license, and they were of course all for the portfolio in issue. Apple preferred its own comparables, save for Qualcomm and a small number of others that it disclaimed that we'll come to, and it preferred to express the price in DPU. We, in reply, put Apple's Qualcomm license in issue as the best of theirs, and in fact, the only one not affected by holdout because of Apple's policy pursuant to which it negotiated licenses. So can I show you a little bit of Apple's comparable case? So that's in their position statement in tab 3. One can perhaps look at page 61 of the bundle. You can see their own case as to the rates one derives from their comparables that they said were useful. and what they said that meant for my client's portfolio. I'm looking at the table. There's the series of Apple comparables they relied upon, and the final column is what they say each one implied is a DPU for my portfolio. Please also note paragraph 46 at the foot of page 61, which is Apple's pleaded case to focus on 4 particular licenses they say are more comparable.
My lords, I hate to rise when my learned friend's on his feet, but he's got a document in front of him that's got highlighting as to what is confidential. He already did it a few moments ago. He needs to be much more careful not to be reading out the highlighted material.
This is the
He
old
referred to 4 comparables. He didn't say what they were. Is that objectionable?
My lord, has marked up in the first line of this document, the number is highlighted.
Are you seriously telling us that can be confidential?
My lord, I'm only trying to deal with it as it's arising on the case.
I mean, that's absurd.
My lord, the difficulty is that a huge amount of effort has gone into determining the confidentiality regime in this case. It's difficult enough with the markups to be dealing with them on the fly to work out whether they're confidential or not.
Yes.
I jumped up and I very much understand my Lord Justice Arnold's point that what's the justification for 4? The answer for that is that one needs to look very carefully back through the agreements, not only between the parties and the rulings of the judge, but with the 37 counterparties who have been put on notice in this case. And what I can't deal with is my learned friend riding roughshod over the agreements and reading out numbers, which I'm then expected to make a call on. Is it sufficiently confidential for me to turn up and interrupt the proceedings in order to deal with them? So all I'm asking my learned friend is more careful with what has been.
No, I follow that.
I'm
But
grateful.
just to be clear, as to that specific instance, I see the number is highlighted. So we understand the scope of your concern. Has Mr. Speck said other things that cause you concern?
My lord, there was an issue where he was looking at Mr. Ankenbrandt's evidence.
Yes.
Back in sub 4 on page 75, we read out an entire sentence that is highlighted. And I didn't react to that quickly enough. Hence my reason for trying to react now. As soon as my learned friend is starting to go into paragraphs that are highlighted, he just needs to be more careful. At trial, we ended up having to use a 15-second delay loop to take confidential material out, and it led to a huge amount of disputes and resolution later. Going back over the transcripts, working out, well, my learned friend was often contending, well, that can't be confidential. And with respect to my learned friend, that's simply not how this works.
Yes. Well, Mr. Speck has said what you have to say.
I'm grateful.
Can we proceed on the basis that you will be even more wary of referring to things that are highlighted in open court?
Well, I am being extremely careful.
Yes.
But the reason that I pointed out earlier on that some of these are overly marked is because this is marking from the trial.
Oh, I see, yes.
So, for instance, I can read out the names of each of those licensees. That is not confidential now. I have no doubt about that, but they're still highlighted here because they were then. My friend is taking a point on old confidentiality markings, and that's why I told my lords that don't be too worried if it's a trial bundle marking. We haven't gone through and done it all again.
Is that an answer?
My lord, I would have to check on this.
Yes.
That's the difficulty.
Yes, I follow. At any rate, to be on the safe side, if Mr. Speck, there's any possibility of something still being confidential, can you avoid giving us that particular information? You can obviously identify it to us in other ways.
Indeed, but for instance, I'm going to make a point as to the identities of licensees that are missing in that table. Identities of licensees are not any longer contended to be confidential. They're all identified in the judgment.
But on names and dates of licenses, that has been specifically agreed as being released.
Yes, I see.
And what I will not be doing is reading out any of the actual numbers.
Yes, I see. Yeah, thank you very much.
Now, what I was going to point out is who's missing. So you can see that that table of the licenses they're relying upon doesn't include all of them. Qualcomm is missing, but so are Orange, KPN and the earlier Etri license. Consistent with their disclaiming reliance upon them, you'll note that's done at paragraph 41 earlier in the pleading. Sticking to the table on page 61 and looking at more detail at the table, and here I am going to just point to numbers. Looking at the numbers in the right-hand column, this is their case as to what DPU would infer for my client's portfolio from the price they unpacked from each of these licenses. They happen to be licenses we say have all been procured pursuant to a negotiating policy that's very aggressively holdout, and I'll come to that. So we say that they've been affected to differing degrees by that, but look at the number for Ericsson in the right-hand column, their own case as to the implied rate that that license gives for my client's portfolio, and compare that to what we know the judge in effect set in this case, a rate of 2 cents a unit. And I will be coming on to the issue that the Ericsson license is not unpacked by Apple in the usual free release way that one might be said to include some generosity by ignoring value for the past. And as I shall explain, exceptionally, this was unpacked in a way by Miss Guttridge, which achieved the opposite effect. But even doing that, on their own case as to the rates implied for my portfolio, you can see the kind of level Ericsson implies. My lord, the detail of the respective top-down cases I think I can take from my skeleton. So this is paragraph 43 of my skeleton. So it's page 59 of the bundle, which my lords are working on it in the bundle. As we explained, we pleaded a case that for 4G multi-mode devices, an overall royalty burden of 15% was reasonable as a top-down cross-check. Apple had different top-down exercises, in fact multiple versions all put forward in DPU terms. It had two what are often referred to as SSPPU approaches, and that's smallest saleable patent practicing unit, and that's a contention that the royalty should be based upon something small in the phone, usually the chipset. One of those was simply to say, well, let's take $5 as the overall pie. The other was a calculation put forward by Miss Guttridge giving an overall price, so for all SEPs, all SEP owners, somewhere just above $1 up to about $1.75. So a rather remarkable contention that $1 should be shared between all SEP owners. In addition to those two SSPPU approaches to top-down, they had an alternative calculation based upon a contention as to profits available on basic level smartphones. And these are set out in our paragraphs 45, subparas B and C. I should also mention that Apple also advanced a case in its skeleton at least that one could add up all the DPUs from the Apple comparables and scale using inography data to the whole stack to get an overall price. As it was made up from data from Apple comparables, we tended to call it apple pie, at least on our side of the case. But the trouble with what they were doing is they obviously left Qualcomm out. And so we, in response, relied upon a corrected version of this by putting Qualcomm back in, which makes a big difference to the overall stack when scaled. And you see the different numbers set out in subparagraph A of our skeleton. They're the highlighted numbers on the top of page 60 of the bundle.
Yes.
Now, my lords, as far as the measure of the share of the overall stack of SEPs, I've already touched on this a little bit. Hopefully you will have grasped this can get deployed in two different ways by the parties. The first is the specific way I referred to earlier when unpacking a license where there's a cross license, but that's a situation where you only ever need a ratio. But the measure of the portfolio is also used as an absolute value as a way to work out Optis's share in a top-down method. And it's also used in comparable cases where the comparable is not for the Optis portfolio. You have to scale from some other portfolio to, for instance, in the Apple licenses. But it's really important that my lords understand you don't need to do that when you've got a comparable which is to the Optis portfolio, but it needs to be used where you've got a comparable that's not that. And on that issue as to how the Optis portfolio share was measured, we've always sought to adopt a measure that dealt with the over-declaration problem. So some kind of measure of truly essential patents. Initially, my clients had the evidence from an expert called Miss Dwyer, looking at the portfolio, but I think you will have picked up that this was withdrawn after the judge made a case management decision to test that by only reference to 3 patents to be picked by Apple, and I think there was some suggestion she wouldn't know which they were until she was in Purdah. I don't think that was ever actually decided, but we withdrew that evidence, and in that regard we did change our case. But Apple seeks to portray Optis as constantly chopping and changing, and that's not fair. Of course we respond to points they make, like correcting their calculated stack by including Qualcomm. And we did change by dropping the Dwyer evidence, and we adopted the use of the PA report, which was in fact already in the case as Apple's alternative fallback measure on the portfolios. Apple's primary case is inography, which, as I've said, doesn't seek to deal with the over-declaration problem, but they had a fallback position on PA. That gives my lords an overview of the respective cases that were in play from the parties. And before I move on, can I draw attention to what we say are 5 key features that were common ground between the parties and in their expert evidence. And this is dealt with in our skeleton at paragraph 46. And I'm obviously drawing attention to this because they're pretty fundamental premises or features of the approaches that were before the judge, and which by rejecting the expert evidence he also threw out. The first, so subpara A at the foot of bundle page 60, is the important point that for meaningful use of a lump sum license to value, whether you're carrying out a comparables approach or using a license to estimate the total price for the entire stack, it should be analysed in a way that implies a per unit price. Whether you have a preference for DPU or ad valorem, that was common ground, and failure to do this ignores variation of consideration with units. And it was a fundamental premise to both sides' valuation that overall consideration paid would depend upon a unit price and an appreciation of the number of units to be sold. Our second point, this is subpara B, relates to past sales. Both experts recognised they needed to address the issue as to the extent to which the consideration included payment for past sales. It was common ground that this was paid for at a reduced rate, if at all. As I've showed you, both parties considered it useful to unpack on the simplifying basis that attributed all consideration to the future sales. And in fact, Apple only did this. The third point, both took account of cross-licensing in Apple licenses. There obviously aren't any in the Optis licenses, but in the Apple licenses where there were, they took account of them, and both sides did this by reference to the sales of the relevant counterparty and Apple's share of the stack. The fourth point, this is subpara D on page 62 of the bundle, the top-down analysis using Apple comparables. So the rival approaches to assessing the overall stack price by adding up the Apple royalties, with or without Qualcomm included, and assessing how much that tells you the whole stack equates to. They both include a number that takes account of the relative size of the portfolios, i.e. how much of the stack they represent. They are not, for example, all normalised as if they all represent 1%, and combined as if of equal importance to the overall price of the stack. And the fifth and final common feature of the parties' approaches is that 4 of the Apple licenses were not relevant for the purposes of valuation. And I think you appreciate that only one of them, Grand Messer, was actually left out by the judge. Those are important features that were common between the parties and thrown out by the judge, in effect, by throwing out everything the experts did. The next point that I should draw attention to is a point that arises as to the unpacking as an exception in a couple of instances to the normal way of doing it that I've explained. And my lords will appreciate that what I've described as free release or simple unpacking, and indeed Mr. Vazant's adjusted unpacking, takes the entirety of the consideration and treats it as attributable to either all of the past and future or only the future. There's an alternative that my lords need to know about. One can take consideration of an agreement and apportion it for whatever reason, so that one only takes part as attributable to future sales. And then one works out the unit price, either AV or DPU, using the apportioned fraction of the consideration and the future projected sales. And there are 2 licenses where this arises. For one, it was agreed between the experts to be the appropriate approach, and for the other, it was hotly disputed. And I'm not going to say anything about the underlying terms in the licenses which gave rise to the point that might be said to be, even at a high level, said to be confidential. I don't know. But what my lords need to know is that in the case of the Qualcomm license, it was agreed between the experts that this alternative approach of unpacking a future-only rate in this way was appropriate. Now, hopefully that my lords will realise that when you do that, it can't be said to be generous by overestimating the unit price in the way that it might be said when you do a free release approach by allocating the entirety of the consideration to future sales when some part of it might have been allocated to the past in the negotiation. And what my lords need to keep in mind is that both experts adopted this approach with Qualcomm. And that is why you will see the numbers for Mr. Bazant's 3 types of unpacking. They're actually the same for all 3 for Qualcomm, because in fact it's an exception and not really a free release, adjusted or simple. It's done this exceptional way, and therefore it's the same. And although the fine detail of Miss Guttridge's sums differ, she did the same, so her free release unpacking is also not strictly free release either. Both are an assessment of this future-only approach based on an apportionment of the consideration as to future sales. And so far so good. There is a second licence where Miss Guttridge also did this, and I've alluded to it already. It's the Ericsson licence, relying upon the evidence of a Miss Witt as to the basis for it, who in fact then didn't come to trial to give evidence. And I'm not going to say anything about the underlying deal that was relied upon, in case Mr. Nicholson jumps up, but there was a big dispute as to this because it had the perverse effect of allocating consideration to the future and the past, so that past sales were valued at a premium. And can I show you this addressed in our closing? So you need supplementary bundle 1. Tab 3, page 82 of the bundle. And it's paragraphs 655 to 658. See in particular the thrust of 657. We will see.
I wasn't paying a proper attention. 655 to 658.
Yes, on page 82 of the
And
bundle.
we need to read those because you're not going to, or will you be able to tell us about them without saying anything controversial?
Yeah, I don't. Other than the numbers, which I'm not going to.
Yes.
The fact that it's Ericsson is not any longer confidential, so I'm not going to read out the degree to which there's a premium.
Yeah.
But the thrust of the point I'm drawing attention to is those 4 paragraphs. But really, in a nutshell, is 657.
Yes.
Now, we will see that dispute referred to in the judgment, but regrettably not decided by the judge. So the upshot here, just to be clear, there was a very big dispute as to whether Miss Guttridge's so-called free release unpacking for Ericsson was in fact a significant undervalue. And I've shown you what she got, what the numbers came out at, even adopting this approach. At this stage, my lords, what I can say, because the unpacking adopted was not the ordinary free release, there's certainly not one where there's any overpricing that one might think there could be a little bit of in a free release. That's not happening at all for Miss Guttridge's unpacking for Ericsson. And as I say, there was a hot dispute that in fact the opposite was going on. And for my lord's note, the cross-examination of Miss Muse on Ericsson is at Sup 1, tab 21, page 290 to 294. Pages 839 to 857 of the manuscript. I'm not going to go through that now, although I do invite my lords to read it if you have time. What I will do is show you a little bit of it. So can I ask you to turn it up? Sure. So it's Sup 1, tab 21. The totality of it is page 290 to 294. But I want to draw attention on this point to 292, page 292 of the bundle, and I tackle this particular issue starting at page 846 of the manuscript, right down to 84 line 10. the key bit is the end of that passage from line 14 on 848 to line 10 on 849.
Would you like us to read those lines?
Yes, please, yes. The point that I make, my lords, is that Miss Muse is just struggling to face up to the question that I'm putting, that it makes no sense for the per unit rate to be higher for the past and the future.
So she doesn't accept your proposition, but she gives no reasons for the contrary view.
She's struggling to face, my submission is that she's actually struggling to face up to the question. My lords, there's a further aspect of the way things shaped up at trial that I need to address, because it's relied upon heavily by my friends, and that's the issue of the questions the judge asked and how the experts dealt with them. Can I ask you to go to the judgment at para 58? This is the part of the judgment which addresses this issue. The 58 is on page 265 of the Core 1 bundle. And my lords will recall that the judge sent a substantial request in the days before the trial started. It forms part of what overall is quite a massive three-way correspondence between the parties and the court through this whole period of trial and consequential hearings. And just dealing with this request was a very substantial task. The response Mr. Bazant prepared fills a mid-sized lever arch file. His response is over 300 pages long, and I'm going to show you an extract shortly. And as paragraph 58 here makes clear, these responses came in during the trial. In fact, Miss Guttridge's response came in whilst Mr. Bazant was being cross-examined. Her response is in fact a much thinner file, but each was a file, and they were called Q2O and Q2A. I think it was question 2, Optis and Apple respectively. And you'll see from paragraph 58 that Miss Guttridge's file was accompanied by an indication that the contents of the file didn't necessarily reproduce or accord with her approach to the unpacking and scaling of the licensing agreements that's set out in her reports, and they don't reflect Apple's case. Despite just how close we were to Miss Guttridge's oral evidence, and despite the fact that Mr. Bazant was already in the box, Apple seems now to suggest I should have cross-examined her on these materials, although they don't mention she wasn't asked to swear to them when she did get into the witness box. The sworn evidence was only that in her report, so they were not put in evidence. And it would in any event have been completely impractical to have analysed all this in the time, even if they had tried to incorporate it into her evidence. But as I say, they didn't. No doubt because some of it was not in accordance with her evidence or approach.
And you say, despite the closeness to the cross-examination of Miss Guttridge, how does that work out in terms of dates?
My recollection is that they went in one after the other. I'll find out and tell my lord.
Yes.
It's 28th and then the 30th.
28th and then the 30th apparently.
June.
So the material came in on the 28th and the cross-examination started on the 30th?
Yes, but my expert was already in the box.
Yes.
But I think the suggestion is that we should have got his team to help me.
And just so I'm clear, on the 29th, Mr. Bazant was still giving evidence?
Probably. They're all nodding, yes.
Yes.
Before I show you an extract of the materials, can I just look at the extract of the transcript that the judge sets out? Can I pick it up at the foot of page 266? You see the judge, this is actually talking to my learned friend Mr. Turner, is referring to discounts for past sales and how they might properly be dealt with, particularly how you might average out the lump sums across past and future sales. I'm looking in particular about 5 lines down into that passage at the second half of page 266. You see him talking about averaging out the lump sum across past and future sales. And if we go over the page, you see that I stand up, perhaps unwisely, to join in. And the point I make is that it would be highly undesirable to have a new set of numbers. And I explained that in the case already there are Miss Guttridge's equivalent of free release. And I explained that Mr. Bazant has done 3 versions. And I said, what I thought the judge was asking for, smoothing out consideration across everything, is in fact his simple. And the judge says he thinks I'm right, and I go on to explain that Miss Guttridge hadn't done that. But it is in the case, obviously referring to Mr. Bazant. I say one might quibble about the source for the predictions of sales, but what the judge is asking for is Mr. Bazant's simple unpacking. And the judge seems to agree and says simple is what he's keen on. He says hopefully we're talking the same language with Apple. And I say they haven't done it and that's the problem. And the judge says he hopes they can, and Mr. Turner says just below halfway they'll speak with Miss Guttridge. And the exchange ends with the judge saying he doesn't know what weight he's going to give to the comparables and says he doesn't have apples for apples comparison. Now, the passage continues with, we see at the foot of page 267, the judge explaining he was hoping for an agreed set of figures. And I'll come back to that very shortly because what he did have was sets of DPU unpacking from either expert on free release, because Mr. Bazant had done that to enable comparison. They were pretty close with each other. Anyway, reading on, the judge gives Qualcomm as an example, and he says he wants to address the arguments about that apart from the figures themselves. Well, that is in fact a good example where the unpacking DPU for each was pretty close. Can I just pause here because I want to make what's an important point. The focus here is on a gap in Miss Guttridge's evidence because Mr. Bazant had done his 3 alternatives and he'd converted his AV free release to free release DPU to enable comparison with Miss Guttridge's single approach. But there was only free release from Miss Guttridge, no equivalent to the simple approach. That's what this is all about. But we see the judge goes on and says in paragraph 60 that he thought the position was clear and then sets out at paragraph 2 that his letter of request was intended to cure deficiencies in the parties' responsive position statements and evidence by obliging each expert to state for each comparable the unpacked lump sum ad valorem or unit royalty rate. Pausing there, this idea of an unpacked lump sum was not a deficiency in the parties responding to each other or their cases because neither side was doing it. Still less was this a clear deficiency. In his subparagraph 3, the judge says his exchange with me, that which he has just quoted in paragraph 59, was, so the judge thought, to clarify that when unpacking on an ad valorem basis of Mr. Bazant's 3 methods, simple unpacking was best. Perhaps a bit early for the judge to be suggesting that, but anyway, he says it was not intended to suggest that Mr. Bazant should continue to fail to provide, as he had so far, implied lump sum royalty rates, and the judge says he believes he was absolutely clear that Miss Guttridge should provide, to the extent she had not done so, simple ad valorem rates. Now the premise of this seems to be that Miss Guttridge had already provided implied lump sum rates, and Mr. Bazant hadn't done the equivalent. That's just wrong. It's all of a muddle in my submission. And it's all of a piece with other parts of the judgment where the judge believes Apple was advancing a case based upon unpacking into lump sum rates. We see the judge then says he was surprised by the way matters developed. In para 61.1, he says Miss Guttridge provided full responses, and he says Mr. Bazant's response was non-responsive. And the rest of paragraph 2 suggests Mr. Bazant declined to provide any response that went beyond what was already in his reports. And he specifically says he declined to provide any calculation of unpacked lump sum royalties. It rather makes it sound like he filed a piece of paper saying he wasn't engaging further and simply referred to his reports. What's apparent is that Mr. Bazant's approach to dealing with the request was to seek to provide the best answers possible based on the information already in the evidence. Perfectly sensible if what the judge was asking for was to be limited to a reslicing of that which was already in the case. Whereas Miss Guttridge didn't try to do that, she departed from that constraint, which is why she had to say that what she'd put in wasn't necessarily in accordance with the evidence. Now, we'll come to it, but it's actually clear that the judge wanted no new evidence. He only wanted what he called reslicing that which was already in the case. So in fact, Mr. Bazant's approach actually accorded more closely to what it transpired the judge said he wanted. But that's not the key point that I make here. Although we objected to the new evidence, we don't criticise Miss Guttridge for approaching the request in the way she did. But I do say, nor is it fair to criticise Mr. Bazant for seeking to give answers as best he could from that which was already in the case. And I've already told my lords that in fact Mr. Bazant's materials were in fact more voluminous and certainly can't fairly be described as a non-responsive response. It was a file full of over 300 pages submitted. Let me just show you an extract. You need supplementary bundle 4, tab 8. This is just 11 pages from a lengthy table. It's the one for the Huawei agreement. And just for a note, Miss Guttridge's pages are in the previous tab. But looking at Mr. Bazant's tab 8, you see his approach is reflected in the heading of the second column. Best available information to respond to the request. That's what he did. And this is what he put in for the just one agreement. Now the point of the judge's criticism is the entry for item I. So if you go to page 113, right at the bottom, this is asking for the actual or implied lump sum. And you can see Mr. Bazant's answer is in fact only directed to the implied part of that request, and that's because the actual lump sum would be in the box above, and of course many were. So
we can see that in H on the right hand side.
Yeah, exactly. So although it says actual or implied, it's really the implied bit, and many were actually actual lump sums, so they were in H. And that's why Mr. Bazant's obviously only focusing on the implied part of the request when he responds. And the judge's complaint is Mr. Bazant had not included this implied, or what the judge now calls unpacked, lump sum in the case of licences that are not lump sum licences. And he explains that that has not been calculated for the comparable in this manner. And of course, we know that that wasn't in Miss Guttridge's evidence either. And nobody was thinking in terms that the judge now sees things, that there's this alternative unpacking of non-lump sum licences into lump sum licences. There wasn't in the evidence information that would enable that to be provided for those licences. one would have to go and work out the actual projected sales figures, for example. Now, my lords, it's of
So,
course.
can I get this straight? I hadn't quite, this hadn't quite dawned on me. So, what you're saying is that whereas it's common practice, we've seen it in several cases before, for a lump sum license to be unpacked so as to try and arrive at a per unit rate, you're saying the judge was wanting the process to be somehow reversed?
Yes, absolutely. Absolutely right. He wanted something where you could read the unit price off the licence. He wanted us to tell him what that would have been as a lump sum. So you need to then go away and work out what would the projected units have been, what might have been the position on what units were covered for the past. And yes, that's exactly what the judge was asking us to do. I mean, it's perhaps... at the time, it didn't seem... I'm not sure it dawned on us just...
I can understand why not.
Yeah, but by the time you get to the... When you get to see what the judge did in the judgment, he basically wants a lump sum for everything, and he's going to average it. He's not interested in what the unit price is. And so we now know, and we'll see in the judgment, that he keeps talking about...
A lump sum in the abstract is completely meaningless.
Well, I'm tempted to sit down now. Absolutely, absolutely. But that's why I'm going to spend some time going through the judgment to show you what he actually does. But it's related to this. And
Sorry, Mr. Speck, forgive me. Just rather like my learned friend, I hadn't quite grasped this point now. So this was the question that the judge had asked in the days before trial.
just in the run-up, and it took quite a long time to put this together, and that's why the answers came in during trial.
Right. Have we got back those questions anywhere? Could you show us where, not necessarily now,
Well,
where the judge
in the
asked
judgment,
the
it set
questions?
some of them out.
It was an entire spreadsheet he wanted filling in.
Yeah, yeah. But we will. I think I'm not entirely. It's definitely in
At
the
some
judgment.
point, it would help me at least if I could see and show me how the judge is expressing the very specific point you're now making.
The judgment has a table at paragraph 57, and it goes over several pages. But what we will do, my lord, is make sure you've got absolutely everything, because there might have been some introductory text. I'm told it's in supplemental 2, tab 1 is the letter. So you get the whole lot.
Yes, I see. Thank you. That's fine.
And just to understand the sequence, so this comes on the 6th of June,
That's before the trial starts.
and the
but only-
trial starts on 13th, is it?
I think that's right, yes. It's a few days before. It's when the judge is doing his reading in.
Yes, I see. And Mr. Bazant goes into the witness box on which day?
28th, I think my friend said.
He was in the witness box.
Oh, right. He might have gone in before, but he was in on the 28th when Miss Guttridge's response came in. I'll tell you what we'll do. I'll put on a piece of paper when he went in the box, when our response went in, when their response came in, and when Miss Guttridge went in the box, to make sure you've got it absolutely.
So far as my Lord Justice Birss's question is concerned, we can see what the judge is asking for on the third page, you get a bit of it at R, which is the row we were just looking at. He says the actual figure or the figure that emerges from the calculation ratio is due to set out. And it becomes a bit clearer what he's talking about when you get to L, where he says if an actual flat rate is proposed, this should be specified, otherwise the implied flat rate should be stated.
M is on ad valorem, though.
But is a flat rate $1 per unit rate? Is that a flat rate?
A flat rate usually is, so that's L. M, I thought maybe I misheard, but my lord said I think M.
Oh, no, yes, so L is not relevant, okay.
No, L and M are alternatives where you are doing an unpacking, a conventional unpacking. I'll show you, my lords, when we get to the judgment. The judge thought that unpacking was going either way. And just to be absolutely clear, the judge thought that, for instance, the lump sum that's paid under the Google license is as good for a lump sum as any of the lump sums paid by Apple under the Apple licenses. He just completely ignores the units dimension. That's where we're going to get to. At this stage, I'm trying to deal with the criticisms he made of Mr. Bazant in responding, though, because my friends are relying upon it to suggest that we were being deliberately unhelpful. And what I'm suggesting is that that's not fair at all. And certainly the response that was put in was voluminous. To suggest that it's a non-response it is just totally unfair. Now, of course, it wasn't this unpacking where you can read the price off of the licence into a lump sum wasn't in the evidence of either side. And Miss Guttridge did do it in her response. But she also did a new equivalent of Mr. Bazant's simple, not in accordance with the evidence or Mr. Bazant's approach. And the judge records what we said about that in our closing at the top of page 269 in the judgment. What you don't actually see is the context that the passage appeared in the closing was actually identifying that simple unpacking wasn't the preferred method anyway. And what I want to show, my lords, if you go to Sup 4, tab 4, page 63, is where it appeared. You see, for example, paragraph 550 on the page precedes the two quoted by the judge, where we draw attention to the fact that it wasn't Mr. Bazant's preferred approach and formed no part of Miss Guttridge's evidence. So what we said about the response was in the context of saying it wasn't the best thing to be doing, it wasn't Mr. Bazant's preferred approach, and it wasn't in Miss Guttridge's evidence. And that's the context in which we said what we did, which the judge set out. And the judge explains in subpara 4 on page 269 of the judgment that he wrote to the parties referring to the responses in files designated Q2A and Q2A. We see the judge says he's troubled by our closing. And that's the paragraph halfway down page 269. He goes on to say he's not prepared to countenance without justification the originating of new evidence, but he says he doesn't understand it to constitute new evidence, but a reworking of material of old evidence according to his request. Now, pausing there, that was true of Mr. Bazant's response, but certainly not true of the totality of Miss Guttridge's, as she made clear. And we see he goes on and asks if the parties can liaise so that they are satisfied the contents of those two bundles constitutes a reslicing of old evidence, not the introduction of new evidence. And as the judge records, in our letter back, we maintain our position. The judge says he's not going to set it out because it was clear to him he couldn't, in the light of those objections, whether well-founded or not, refer to or in any way consider the material in file Q2A without reopening the hearing. And he also refers to and quotes our explanation as to why providing an implied lump sum would constitute new evidence. Can I show you the first of those two letters that the judge didn't set out any of the detail on? Again, it's in Sup 4, tab 10, page 127. We refer in the introduction, so this is the foot of the page 127, that at the PTR, when a new licence had been signed and Optis sought to introduce a new unpacking, and much earlier than this material, obviously it wasn't capable of being brought in. And our answer to the judge over the page on to his letter, in a nutshell, is right at the foot of page 128. The contents of Q2A is not simply a reslicing of old evidence, and we give detailed reasons in the passage that starts right at the foot of 129. You see it says Optis objections in detail. And let me just pick out one example. So page 131, Rule 1. Miss Guttridge made blanket assumptions as to past releases contrary to other evidence, and we give some bullet point examples. And, my lords, the point put shortly is the one I foreshadowed earlier, and it's this. If you have a release in a renewal agreement, whether a complete renewal or perhaps one where some generations were covered by a previous licence, you don't just assume sales in the past were covered and providing value when you know they're already licensed under a previous arrangement. But that's what Miss Guttridge did. It wasn't, as I think my friend suggests, an essentially mechanical exercise carried out on existing evidence. It was a new approach, which actually we would have said, and do say, is quite wrong. Anyway, the upshot, as we saw in para 61.5 of the judgment, is the judge didn't feel able to dismiss these objections, we say because they're well founded, but his acceptance that he couldn't rely upon this really should have been the end of it. And of course the reason Mr. Besant took the approach to his responses was exactly the same, so as not to put in anything that wasn't just a reslicing of evidence that was already in. So, my lords, we do say the description of Mr. Besant's response to the queries the judge raised as non-responsive is grossly unfair. There was a whole file full of his response, and what he was doing is taking the best information possible to address each request. Perfectly sensible, and as it turns out, the judge didn't want new evidence. But one can't help but be left with the feeling when you read the judgment that somehow the judge thought it was our fault. And certainly that's the way my friends seek to deploy it. My lords, it's taken a long time, but can I finally turn to look at what the judge did in detail? And this will take some time to work through. And I want to start, if I may, with the part of the judgment where the judge rejects the entirety of the expert evidence on both sides.
And as I try to clear the decks, can I safely put away everything but the judgment, or will that prove to be a misguided approach?
It's not misguided, I don't think. It's a good idea to clear the decks. I'm sure I'll ask you to turn something up in a minute, but
I'll do that.
So you need core one.
Yep.
And I want to start with the parts of the judgment where he rejects the entirety of the expert evidence on both sides. This starts at paragraph 311 on page 392, using the bundled page numbers. And as you see from the first sentence of paragraph 311, the judge says he's derived no benefit from the work of either valuation expert and rejects their evidence as unhelpful in resolving the Frand question. So pausing there before we get into any detail, he's rejecting everything they did. There's no benefit in any of the work either expert carried out. And as we shall see, and this is really important, he does so without comparing what the experts did with any alternative. A striking thing about this passage of the judgment is that it is most definitely not an exercise in comparing the strengths and weaknesses of the expert's approach, and in particular the aspects of it that were common between them that I've drawn attention to, the comparatively minor significance of the difference between them. Doesn't do that and analyse it as against any alternative, most specifically his alternative. And the reason I say that is because it's in the nature of a valuation exercise that one can think of and advance criticisms of just about anything that is done. But that rather misses the point. A rejection of the totality of the party's expert evidence, much of which was common ground, really did require not only a proper opportunity for us to be heard, but a proper analysis comparing the alternative that's going to be preferred. And he just doesn't do it. The judge's reasons for his rejection of all the expert evidence starts at 3:12. He states that the nature of the comparables in this case has taken the experts far outside the zone of their proper expertise. He goes on and says both experts would have approached a typical valuation exercise with competence and skill. And he refers back to para 295 here, which is at the foot of page 388. Here, he's referring to an assessment based upon a pool of transactions which relate to identifiable objective factors, and gives as an example valuing domestic property by reference to the factors he identifies there, such as freehold, leasehold, so on. That's what he's referring to. Returning back to para 31213, page 392.
Just before we get into the detail, can you help me on this? As we've seen 311, the judge rejects the evidence of both sides' experts. Do we find anywhere in the judgment any explanation as to how that is consistent with what had been done in the previous cases?
No.
Where, of course, very similar evidence, in some cases from the same expert,
Indeed.
had been relied upon by the
No,
courts.
no, we don't. And my Lord will understand that part of my complaint is there wasn't any submissions on this. It just happened. This is what my Lord's identified as the kind of point that would have been put to the judge in an argument.
Thank you.
But returning to paragraph 312 on page 392, his point seems to be that the disagreement on a more conventional or the more objective factors in valuing a house, for instance, would have been as to the exercise of judgment as regards a common and commonly understood set of comparators. With the greatest respect to the judge, valuation of the kind we're concerned with may be a more specialised field than valuing houses. People with expertise we are concerned with may be fewer in number, but the dismissal of their evidence as unhelpful because they were dealing with features that were not as commonly considered or understood as the features looked at in house valuations.
You say that in principle it's actually no different at all.
Well, it's in principle no different, but these people had expertise in this field.
Yeah.
And it is grossly unfair to the experts and their expertise. And they certainly were not straying outside their expertise. Now, over the page, we see the judge refer to his earlier expressed view that Optis and Apple comparables were categorically different.
Can I just ask you this? Was it put to either expert in cross-examination that they were straying outside their proper field of expertise?
not that I can remember, but that's a question
Because
about.
of course it's we're going to bear in mind that we're concerned here with the professional reputation of experts. And normally, if it's to be suggested that an expert has strayed outside his or her field of expertise, that's a substantial criticism, and one would expect it to be put to the expert in cross-examination for them to answer it.
It was neither side's case that the judge should throw out the totality of the expert evidence. So, certainly to the best of my recollection, but my lord will appreciate it was a long trial, a long time ago now. I don't remember even an aspect of their evidence being suggested to be straying outside, but certainly not wholesale straying outside.
I haven't quite seen where the judge explains why he thought they were straying outside their expertise.
Well, I'm going to
Is
show you.
that
I'm going to show you what he does say, but I don't think he actually says why he thinks they're straying outside their expertise. He explains why he thinks what they're doing has an insuperable problem. There are three things called the subjectivities that I'm going to come to. But I don't think he actually says why that particular sentence is there. Now, I think I was on the point where over the page he's referred to his earlier expressed view that the Optis and Apple comparables were categorically different. That, just for my Lord's note, is a reference back to page 388 of the judgment, paras 292 to 294, where the essence of the point being made is that the Optis comparables are all for a licence to the Optis portfolio. As the judge says, a series of values for one thing, the portfolio, and he contrasts that to the Apple comparables where the common factor is Apple, i.e. they are licences to different portfolios with different counterparties. Quite so, my lords, and you will appreciate we say that's a hugely significant point on comparability. That's what he's referring to there. And we suggest that previous licences for the portfolio being valued are the key source, perhaps the key source of information. Reverting back to paragraph...
So the proposition seems to be that because one side relies upon comparable licences, which you say were plainly not comparable, somehow that impacts on the expertise of the experts.
I'm not sure that fact itself impacts on the expertise of the experts. I think he'd have
He's
said...
given reasons here for why he's rejecting the evidence of both experts.
Say that here he says it's a surmountable difficulty. So
Yes.
he's not saying it's outside.
We're going to get to the
expertise.
insurmountable difficulties in a minute, but
Well, he says it's one that neither party's expert made any effort to surmount.
yes, but, I mean, my expert was obviously relying upon the Optis comparables. And insofar as we said there was a helpful Apple one, we pointed to Qualcomm. But my lord,
Yeah, all right.
there's a lot
sorry.
of this where
Yeah.
we look at it and we just think, what's that got to do with what was being debated?
Yeah, all right. So let's move on.
I mean, just on 313, just to make sure I'm not misunderstanding. So the first sentence says they're categorically different in the sense, categorical in the sense of a different category rather than an emphasis. I get that.
And it's the point, and that's why
Yes,
I took
that's the
you
point.
back.
Because one's one's Optis and the other's Apple. That's
Yes, but he's making more of a point than just that. He's saying that the Optis ones are all for the one portfolio. The Apple one as a category, the only common thing is Apple, so it's all for different
yes.
portfolios.
I see. Okay. So yes, one is the licensee in common, the other's the licensee.
Yeah, and
Okay.
that's why I took you back to where he was explaining that, because that's what he makes plain there.
But to say that well, whether Ms. Guttridge and Mr. Besant individually could or should or did do anything to take those factors into account, I certainly understood both sides to have taken those factors into account in the material they were presenting to the court.
It's certainly insofar as points like the best place to look is for the same portfolio. Indeed,
Yeah.
indeed. I was just about to say that we're on our side of the court. We're not at all sure what he's really referring to, where he says that neither party's experts made any effort to surmount this. We don't know what it is that he's suggesting could have been in the expert evidence that was missing, some detailed analysis on the difference that he's talking about. We just don't know what else could have been included. I mean, both sides faced up to the fact that they were different. One of our criticisms, actually, of Miss Guttridge, you'll see it later, is that she approached the exercise as if there was a special price for Apple. And we say that's not right. And that wasn't a criticism that meant everything she did should be thrown out, but we did criticise that aspect of her approach.
Presumably there was evidence, well, I shouldn't assume, was there evidence, for example, taking two Apple comparables, doesn't matter what they were, A and B, to say, well, the portfolio size based on whether it's inography or BA, doesn't matter, portfolio size being licensed for A was 1% of the total stack and the portfolio for B was 2% of the total stack, and that's a way in which you can render those two licenses comparable with each other by reference to the size of the patent portfolio.
Yeah, that's the unpacking.
Exactly.
Yes.
But that's an example, at least it seems to me, of what's described as not happening in this
Yeah, I think certainly if that's what he's describing, it was done. I think the judge is actually suggesting there that there should have been some more fundamental analysis of what happens when you've got two different categories of license. I honestly don't know, right. but that might be what he's suggesting, and we don't know what that might have been. Paragraph 314 moves to what the judge says is the insurmountable difficulty. So this is the real issue that causes him to reject everything they've done. And he says this is how to resolve what he calls the three subjectivities. And just to identify what that is in reference to, there are the three topics earlier identified at paragraph 301 on page 390. And that's what the judge calls first, different rates, second, cross licenses, and third, future royalties and past releases. And we can see here from para 303 that what the judge means by his different rates descriptor is the point that royalties payable under licenses may be expressed as a lump sum, ad valorem, or here he actually remembers per unit, so DPU.
In what sense are these things subjective?
They're not at all. You have to make, when one comes to some of the others that you're dealing with, or in fact this even, I suppose, the decision as to, for instance, what the units are when you're going from a lump sum to a DPU, for instance, is a decision you have to make. And I think that's what he's getting at. You have to make decisions. And just to foreshadow where I'm going, what the judge didn't seem to realise is that he had to make decisions on all these matters in his approach as well. Some of them, I'm afraid I'm going to be submitting, were terrible decisions, but he still had to make the decisions. Now, it's clear the judge has in mind here in 303, he specifically refers to these as ways in which royalties under a licence can be computed. You see that in the second line of 303. And it's clear that the judge has in mind that ad valorem and DPU, those are the ones where you have a per unit price, it's somehow deficient because one doesn't know what the totality of the money payable under the licence is. You only know that when you see the sales volumes, and we see he refers to that point in both subparagraphs 2 and 3. You don't know what the money is, what the licence is actually worth. And at the end of subparagraph level 3 on the flat unit rate, the judge says, this is the top of page 391, that converting or unpacking a lump sum rate, and I pause to draw attention again to the fact that it's noticeable, it often refers to a lump sum payment with the word rate tacked on the end, reflecting his misunderstanding that a lump sum itself is not an approach to valuation, but just a payment mechanism. Anyway, he says unpacking a lump sum rate into either an ad valorem or per unit rate will typically involve making an assumption about ASP, which he says might not be readily to hand or reliable. ASP is the average selling price. It's simply the overall revenue divided by units. I'll just pause while I'm here to identify another example. This is another example of a sentence that reveals a real muddle on the part of the judge. You obviously don't need the ASP to unpack a lump sum to express a DPU price. If I pay $100 for a license and it's anticipated I will sell 100 handsets, the DPU is $1. That's that whatever I'm selling it for. The second subjectivity in the judge's trilogy is the issue of cross licenses, and the judge notes that there's no such complication in the Optis comparables. That's his paragraph 305. But it is a point on the Apple comparables. And he goes on in paragraph 306 to refer to those licenses producing a net rate to be paid and do not attribute a specific value to the Apple portfolio. Again, he's using rate in a very unusual way. There's certainly a net amount to be paid because a lump sum payment structure has been adopted. And that lump sum's been packed up, which obviously notionally has payments either way to take into account. That's what he's worried about there. And the third and final subjectivity is what the judge calls future royalties and past releases. This is his paragraph 307, where the judge notes that licenses often are in respect of future sales and have releases for the past. And he says generally such licenses don't differentiate between the past and the future. He says providing for a single rate.
How on earth do you know that if it's a lump sum?
Well, it's because he's using the word, I was just about to pause here and say the use of the word rate is really problematic here. He's making it sound as if the licenses provide for a single rate in the sense of a price for sales, whether it be DPU and so on. It's not the characteristic that the judge is seeking to address. It's where there's a single payment of a lump sum. And he keeps using rate as meaning, he thinks a lump sum can be described as a rate. It's absolutely clear. And he talks about lump sum rate all the way through, and it is a real problem. Because obviously the whole point about how you're dealing with unpacking a lump sum where you think that the past and the future have had different prices is that there's not a single rate for the future and past sales. Anyway, those are the three insurmountable subjectivities. And can I just pause and make the following point about them? The first, what the judge refers to as different rates, stating there are three types, one of which is the lump sum rate. That is a manifestation of the judge getting into a muddle over valuation approaches, i.e. how one may compute what is to be paid as against a payment structure. And the muddle has echoes of earlier bits in the judgment back on pages 259 and 260 of the bundle. This is paragraph 55 little 2b. So at the bottom of 259, he states Apple was contending for a lump sum, but was not saying that an ad valorem rate be used and simply converted into a lump sum. He also says in a sentence added after the parties proposed corrections that Apple, nor was Apple suggesting a similar approach using a per unit rate. Well, it in fact was, as I've said, is common ground, and it's the footnote that I've shown my rules already, that you see footnote 59, where he's got in a complete muddle as to what Apple's case actually was. And that is perhaps an even more clear instance of the judge just fundamentally misunderstanding what the evidence before him was doing. Lump sums were never treated as an approach to valuation as such by any expert. And we agreed with Apple's point that was submitted that caused this footnote. And we said so at the time. And can I just take a moment to show you that? You need the extensive correction document that the parties put together, and it's in Supplementary Bundle 3. Tab 13. And what we did is put together stuff which was in black, which was agreed, and then blue and green, the respective parties' positions. Apple is blue, we're green.
Sorry, which tab was it?
Sorry, 13 in
13.
core. Yeah. So it starts on page 1, 2, 3, and it deals with quite a lot of topics, and I think it went in with tables as well, but you haven't been given the tables. What I want to show my lords, if I can, is paragraphs 105 to 108 on page 139. This is blue, so this is Apple. They set out, in fact, 3 places in the judgment where the judge's error manifests itself, and para 55.2b is the first of them, the one I've just been showing you. Look, please, at paragraph 108, explaining very clearly that lump sum is an appropriate payment structure, not itself a mechanism for calculating royalties. And they go on and very properly point out a lump sum can be arrived at by both an ad valorem or per unit, that's a DPU approach. And they go on and state the uncontested evidence and so forth. But if you turn over the page, you see the green text at the top of page 140 actually directs us to paragraphs 184 to 187 for Optis text. And if we go to that, it starts on page 153. And we actually pick out another place where the text rather reveals the judge's muddle. If you turn over the page and just pick it up at 187, we see we also state that Optis didn't object to the payment structure being a lump sum. And we go on and echo what we've seen Apple say already, that Optis' case and Apple's case was that a lump sum was not in itself a mechanism for calculating royalties, and explain that the dispute between the parties was as between getting to the lump sum payment via per unit, i.e. DPU or ad valorem. And my Lord see underneath Apple's respond in substance by agreeing. But despite this, the judge stuck to his guns. And what the judge's rejection of this agreed correction shows, and what's reflected again in the different rates section of the judge's subjectivities section, is a really fundamental failure on the part of the judge to appreciate the basics of the expert's approaches. My lords, the second of the judge's subjectivities, cross-licenses, is something in due course we will see the judge has to deal with as he adopts almost only Apple licenses. On our side of the court, we have real difficulty with this being explained as a feature of the expert's approach that's insurmountable. One of the 3 key features that drove the judge to reject the expert evidence because they had to deal with cross-licenses, but then he had to. We will see in due course that the judge has to deal with it, and in fact he deals with it in a completely unsatisfactory way. Just to foreshadow that, basically he completely ignores the relative level of sales and simply calculates what he calls a net stack share. But the point I make at this point in the argument is that the explanation that he's rejecting the experts because their unpacking has to accommodate this insurmountable issue of cross-licensing is no distinction over what he eventually does. one can see he relies upon this at the end of para 310. Specifically as regards Miss Guttridge's treatment of the Apple licences, is relying upon having to deal with the cross licences because they're Apple comparables. And this really is a start point where the absence of any attempt to look at what he's rejecting as against any alternative, in particular his, really comes home to bite. And we'll be coming back to that on grounds 2 and 4. If he'd done that, he'd have appreciated it's no criticism of the expert's approaches at all. My lords, I can make a similar point about the third subjectivity, the past and future sales point. When we get to it, we'll see the judge had to address this point too. And he again did it in a completely unsatisfactory way. He simply split the money in half. But that was a decision he made as to deal with it. We say it's completely unsustainable, but at this point, I make the same point. His view was that having to deal with it was a reason to dismiss the expert's
He said it was
approach.
an insurmountable problem.
Indeed.
It's insurmountable if there's no solution.
Well, and he's saying, I'm not going with the expert's approach because an insurmountable problem is you've got to deal with this problem on their approach. And then he goes and picks an approach where he's got to deal with this issue. Whilst on this point, my lords, you'll see he explains the detail of how the respective experts did approach matters in their evidence in his paragraphs 308 to 310. And these paragraphs explain first in para 308 that Miss Guttridge, so Apple, only unpacked Apple on a free release basis. As we know, that's treating the past as having no value, save for the 2 exceptional cases, that is. And this paragraph also records that she was happy to adopt Mr. Besant's analysis of the Optis licences and to apply an adjustment to match Apple's view as to Optis stack share. Just pausing to explain that, that's a reference to Miss Guttridge taking Mr. Besant's unpacking as to what it showed was in fact paid, but then adjusting it by suggesting that the licensee agreed the price on a misunderstanding of the size of Optis portfolio that was wrong, so the price should have been lower by the factor Apple said the stack was wrong by. So he's quite right that Miss Guttridge was happy to adopt Mr. Besant's analysis as to the actual price paid, and she did the exercise that I've just summarised. Paragraph 309 goes on to explain Mr. Besant's 3 approaches to dealing with past and future sales point. That's the 3 different bases for unpacking that we've covered. So, my lords, that was a rather substantial detour from paragraph 314 to explain what the key points, the insurmountable issues of the judge's 3 subjectivities were. Can I take you back to 314? Because the judge goes on to make further criticisms of the experts, the essence of which is that they were not sufficiently independent and were restrained by their instructions. So if we look at para 314 little 1 on page 393, we see the judge says Mr. Besant was instructed as to the way he should approach valuation. And the first point made is as to this is that he was instructed to consider a comparables approach only. The footnote refers to the statement in his first report as to his instructions to apply the comparables approach for the purpose of that report. Now, my lords, at that point in time, because of the unusual procedure the judge had adopted of basically directing the parties to have a clean slate with the pleadings and serve them with their evidence by position statements that would come with the evidence, what else was he supposed to do? The quote the judge gives is from the introductory passage of his first report, where Mr. Besant explains there are generally two types of approach, comparables and top-down. But a top-down is obviously wholly dependent upon a view of the appropriate stack price and some kind of technical assessment of the stack share. The rest is simple arithmetic, as was Optis' case on scaling from unwired planets decision. The impression given here by the judge is that somehow there was something else, and more generally that Mr. Besant was prevented by instruction from looking at, for instance, Apple's approach. But we didn't have it at that point. We would see it when the reports and the position statements were exchanged, and thereafter Mr. Besant certainly did engage with Miss Guttridge's evidence and approach.
And sorry, engaged in a further report. I mean, I haven't looked.
There were loads of, yes.
There are lots of
There's at least 5.
Yes.
The next criticism in this sub-paragraph as to Mr. Besant being instructed which licences to look at. This criticism appears from footnote 436 that he's looking at this point in time only at Optis licences. I'll just pause here and say that's a quite extraordinary criticism. At this stage, it's Optis' positive case being advanced, provided with the pleading in the position statement. We don't yet have Apple's case and its analysis of its licences. Mr. Besant certainly did engage with that in his reply reports. There are significant sections directed to the Apple licences. And moreover, can I just pause to draw attention to the fact that earlier in the judgment, as regards which of the Optis licences Mr. Besant covered in his evidence, there's precisely the opposite view expressed. Can I show you that? Page 362. So para 236, he refers to the fact that Mr. Besant didn't stick to the Optis licences pleaded as he'd reviewed all of them. So para 236, seeing that he's talking about he gave his evidence referring to Optis comparables going beyond the Optis comparables capital O, capital C. So he basically looked at them all, so he gives evidence about them all. The thrust of the complaint is that he should have constrained himself to the Optis pleaded case.
Whereas if he'd ignored them, he might well have been criticised for ignoring relevant material.
Indeed, and in fact, seems to, later on in the judgment, he's being criticised.
The usual criticism of experts is that they've ignored relevant material, not that they've taken it into account.
I know. But there it is. So the thrust of the complaint is he should have constrained himself there to the Optis pleaded case, and if Optis pleading was a licence that wasn't useful, we should have followed the party line and not covered it. Yet in that later paragraph, 314, the criticism seems to be he should have decided for himself what to include in his evidence and not restricted himself to what Optis rely upon. Of course, it's not a good criticism at that point because it's just the positive case on the Optis licences that he's addressing. My Lord, the third criticism in paragraph 314 on page 393, I'm afraid is yet another manifestation of the judge simply not understanding the fundamentals, that a lump sum was a payment structure, not a method of calculating royalties. Because here we see the judge stating that Mr. Besant unpacked lump sum royalties into ad valorem, and he says this, without doing the reverse, i.e. converting ad valorem royalties into lump sum royalties. I don't know what lump sum royalties are, I have to say. It's totally confused in my submission. What does it even mean to take, for example, a licence with an ad valorem price and unpack it to a lump sum royalty? Even more inexplicable, my lords, the judge goes on and infers that even though Mr. Besant does not say he was instructed to approach the issue of unpacking in this way, that must have been the case. I mean, this is completely extraordinary in my submission. Nobody's ever turned their mind to the idea that there's some lump sum approach to valuation which might call for a non-lump sum licences to be unpacked or converted into a lump sum. Even more extraordinary in my submission is the following text. The judge says it must be the case that Mr. Besant was instructed not to unpack ad valorem rates to a lump sum royalty because he, the judge, is going to explain later that that is a key factor in answering the Fran question. The implication in that is not only that it is a key factor, something we completely refute, but it was something the judge came up with himself later. But the implication is, the silent premise, is that Mr. Besant ought to have had his crystal ball out and must have known this was coming. Namely, that the quotes unpacking ad valorem to lump sum royalty was a key factor in answering the Fran question, and he must have been told by the legal team as a matter of instruction not to do it. It's extraordinary, my lord, it really is. And it's just all part and parcel of the muddle that the judge got into. And actually what you can see here is the judge is completely missing the real dispute. Because the paragraph ends by saying that ad valorem as opposed to lump sum must be justified, not followed or assumed without question. He's completely missed the real dispute, which is as between DPU or ad valorem, which Mr. Besant did address. But this passage just shows how little the judge actually understood as to the fundamentals of the evidence before him in my submission. And in my submission, there's absolutely nothing in any of these points that will come close to rejecting everything Mr. Besant did in his evidence as unhelpful. Now, the criticism of Miss Guttridge is in subparagraph 2, and the point the judge is dealing with here is a criticism we made of her approach in approaching the issue as if there was a special licence for Apple. And the passage of transcript that's set out is long, but that's the essence of it. And it is a serious criticism of her approach. But it's not something that means that nothing whatever in her evidence is of any relevance or use, and certainly not that all of her unpacking is useless. Of course, her work was more limited. She only did the free release approach. And there were differences in, for instance, the way sales projections were done. But we didn't suggest that there was nothing of use in her unpacking as a result of this a special Apple price point. Perhaps more strangely, this aspect of Miss Guttridge's approach, a special price for Apple, actually ends up being as part of the judge's approach. We'll come to it. But he's setting it out as a criticism as one of the reasons that he's rejecting Miss Guttridge here. And this section, the judge rounds off this section at paragraph 315 at the foot of page 396 by repeating his view that the direction of travel of the experts' reports was set down by the parties who instructed them, and again he says all they did was follow that and unpack in accordance with their principals' respective stances. That really isn't a fair criticism of either expert's unpacking in my submission.
Mr. Speck, prior to Ms. Guttridge's evidence, which, well, you say is not evidence exactly, the material that came in response to the judge's question, did Ms. Guttridge convert ad valorem rates into lump sums?
No. No. If I hadn't said that when we were going through that, I'd intended to.
No, maybe you did.
It came in then.
Yes, that's what I thought you were saying. But
Yeah, nobody did that. And we see at the end of this section, this is paragraph 317 over the page, yet another instance of the judge muddling up lump sum as a method of calculating royalties, where he again wrongly asserts Apple's case was for lump sum royalties in the context of asking why neither side sought to justify their respective preference. So, my lords, he's muddled up again there. That is the judge rejecting all the experts' work and evidence and the reasons he gave, which I have to say betrays a pretty fundamental misunderstanding on the part of the judge, which caused him to make unfair and unfounded criticisms of both experts in my submission. Now, the judge articulated his own approach, which I'm just about to move on to.
And that's probably going to be convenient moment.
Certainly is, yes.
In which case, 2 o'clock.